Song Talk Radio.
I'm good, and you? No, no legal advice. Yeah, I guess I can do the disclaimer now. Whatever I say in this, it's not legal advice, should not be taken as legal advice, and should not rely or take or fail to take any action based on any information that is given. And that if you should not delay in seeking legal advice because of something you've seen or heard during this talk. So, this talk is for information and educational purposes only, and it is not legal advice. So, in a nutshell, yeah. I'm not, not yet. Yeah. Where do we start? Start at the very beginning, which is just the best place to start. Yes. You may, I mean, it's so interesting hearing my bio. It makes me sound impressive. Yeah, so copyright is really interesting in terms of Canadian law. It's a federal law, so it's from coast to coast. It's pretty much the same from, Vancouver Island to Newfoundland. It has its background in English common law. So the first Copyright Act, or I guess of what we would consider the first Copyright Act in the common law jurisdiction was the Queen's Anne Act in 1710, 1711. And that was really because of issues surrounding um, the printer's press and the sort of monopolies that were involved there. So there was sort of this need to give copyright to the artists. And, there's always this interesting thing of like, why do we have copyright? What is copyright? Copyright really is the protection for artists if they create something, they can employ these rights to protect their works. But it is a balancing act between trying to protect the writer and the creator, whoever the author is, the creation of their work, as well as the sort of public's demand and need for it. So, it sits within the intellectual property world. The other two big areas are trademarks and patents, and copyright really focuses more on the creative works. So, literary works, dramatic works, artistic works, and that can also fall into areas like software coding is also falls under copyright and not under what you would think patent, which would be typically what most technology would fall under. Which I'm saying rather ineloquently. But well, the public interest is first of all the culture that comes with the creation of copyright, the use of it. So that's where you fall into things like fair dealing, which is ways that you can use copyright without receiving permission. There are only about 6 categories in Canadian law, and the test to determine if it's fair is, does it fall into one of those categories, and was it fair which was used. um, Parody is one of them. Yeah, critique is another one. Critique actually requires also naming the source. um, but fair dealing is not it's funny because people think of it as a defense. It's actually not a defense. It's actually considered a user's right. So it's it's the public's essential right to it. There's also the idea of, in copyright, protecting the expression, not the idea. So if somebody paints a picture of a sunflower, they don't get the copyright of painting all pictures of sunflowers. It is just the expression of that to give that person monopoly over all paintings of sunflowers would make the act essentially inoperative. So there is sort of this protection of trying to balance protecting and rewarding the creator of the piece of work, but also people who are, let's say, inspired or have or are creating something similar in this. It's kind of like in a vacuum of a similar type of product, and being protected in that sense. So yeah. Yeah. Pretty much, yeah. I mean, there would be also the idea of if you create something, it must be original. What is original? Something that involves a level of skill and judgment. That's the Canadian law. For Americans, it's there's a level of spirit of creativity, and in the UK, it's sweat of the brow. But in Canada, it's skill and judgment. So there's a level of skill involved and a level of judgment. So the question is if somebody is taking, raw like notes in a meeting, is that copyright? Um, so it depends if there's a level of skill and judgment involved. Um, so yeah, when you create like a song or a piece of music, and of course we can get into like the AI discussion if you're using AI to create like what is involved in that, is that yes, it is copyrightable. Uh, and if there's issues around proving its ownership and copyrightability, I mean, generally the first author of creation is considered the owner of the copyright, unless they are doing it, unless there's they're doing it under like a work for hire situation and there's no contract saying otherwise that they would own the work. So, yes, generally that is correct. If you create something, it is copyrightable. The idea to register now, registering is, should you register, should you not? It really depends on the situation, how you're going to be using that piece of art, like that work, that, music. Is there going to be title transfers? Is it going to be licensed, and you want that sort of title of ownership that's there so that if it gets contested, if you want to, it's not the nicest term, but exploit the piece of work, that could be a reason to register. Registering is unlike trademark or patents where you typically need an agent. It can get very technical. Copyright is not as difficult, it's not as expensive. It's definitely less than $200 through the. No, SOCAN is different. SOCAN is essentially they're an organization that collects royalties, from what I remember. And actually, there's two different types of SOCANs. That one that involves, because when you create a piece of music, there's usually two copyrights that emerge. There is the actual performance of the song, and then there's the actual record of it. So there's actually two copyrights that emerge. So SOCAN would be looking at royalties in both those areas. But no, the copyright board is completely different from SOCAN. Yeah, you get like a certificate and title, and then, that is an official record that you can go to court. That, let's say, if you're writing music for a show, a for a film, and it wants to be licensed, this is how you can show the title ownership. If there's issues around it, surrounding, you know, uh, insurance issues. Let's say an insurance company says, we're concerned this song is created using AI, and you come and you say, well, no, I was, received copyright over it. This is the title of ownership. It's, that it's a level of security in that sense. Yeah, it does. I mean, and I don't know if I've ever seen a case that involves that. I'd be curious. I kind of want to look that up maybe and see if that's real. But I have heard it. Yeah, you take a script and you put it in the mail, and I mean, it seems relatively easy to do it. It's now all online. Like it's yeah. Mhm. Yeah. 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 Mhm. Mhm. Yeah. Yeah. You could definitely probably have that. I'm not exactly sure on that totally. I do know that copyright allows for joint authorship, and so you would have both joint authors, whether it's a split or there's a recognition that maybe somebody has, I'm using the music and lyrics, and one has the book. I'm not exactly entirely sure. Um, but copyright does recognize for joint authorship. Uh, yeah, it would be one copyright for that they both own. Yeah, that one or more, two or more would own. Yeah. Copyright cases recently. Well, they were really interesting. Yes, we have definitely had some interesting cases. The most notable copyright case in Canada is the Law Society of Upper Canada, which is now the Law Society of Ontario, versus CCH, which is like a publisher of like a law journal of like different court cases. And so that really has almost everything in there. And it basically it's really it doesn't sound like an interesting case, but they really fought over like, because law decisions are public domain and they're just taking them and putting them in law journal, like where is the originality for the copyright? And that's where the test of skill and judgment comes from, because they said, well, the head note that they're writing was actually the decision. um, there's some other, I mean, there was one case that involved Tommy Wiseau and the documentary Room Full of Spoons, where he sued them saying they had no right to use his material in his film. And, the court actually determined, well, this was a work of fair dealing. They're commenting on uh, the cultural and creation of the film. They need the film and they only use like 12 minutes of the film. So it's also just interesting because you get to read about Tommy Wiseau's antics during the case. So that's a really interesting case. Um, there's one case that involved the Conservative Party of Canada and CBC sued the CPC for using their clips in these sort of social media clips, and it was considered, even though they're not soliciting for money. They said, well, they were soliciting for votes, and that's sort of transactional in and of itself. And so that was a really interesting kind of take on that. My least favorite copyright case is the case Teberge, which was about um, they were buying the artist's work and taking it and placing it onto a canvas. and essentially blowing up the piece of work that they bought. And and the court determined that that was not a copy because they were essentially destroying the other work. And so they didn't want to recognize that it was a copy. It was a really, to this day, I still don't fully understand how the court got to where they were. I think part of it was because they didn't want to recognize what's called the resale right or droit de destination, which is it exists in other jurisdictions, but it's basically it gives artists a right to, if there's a resale of their work, that they get a continued percentage from that work. Canada does not have that in the Copyright Act. And so the court didn't want to recognize that, essentially. And, it's interesting because it's a very French concept, and all the judges from Quebec were very much in favor of recognizing the right, and all of the judges from the rest of Canada in English common law tradition were like, no. Which is really interesting too. That's what makes it such an interesting case, and why I dislike it so much. And I get it's not just a dislike, it's just like fascinating dislike. Like a frustration, a fascinating frustration. Yes, I mean, there's been this. SOCAN is very active in the court system, which is great. There is the really interesting case of they were suing for of how to determine. How you will go on iTunes and it'll play a part of the song before you buy it. So there was this idea that you should be paid for both, or how to recognize how artists should be paid for that, for the preview and also the purchase of the song. It was found that the preview actually fell under fair dealing because it was seen as education, as like research of the individual research and education that the consumer was doing in order whether they wanted to purchase the song or not, if that was the correct song or not. So yeah, yeah, it was like an ad, yeah, which to me is probably my favorite of the SOCAN cases. There's quite a few, but that's probably my favorite one for sure. Mhm. 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 So copyright law requires for copyright to exist, like for copyright infringement to exist, requires something called substantial taking. So it must be a substantial part of the piece. Now, interestingly enough, that doesn't, it's not a quantitative. It's not like you need to, if you take more than 30%, it will add that in. It's qualitative, which means that if, let's say, the opening riff to Sweet Child of Mine is very distinct. If I took that, it's very distinct, even though it's very short. And therefore, it would be a substantial taking. So it really depends on. I mean, your other guest wasn't completely wrong that if you removed it, then it could still exist as its form. Basically, that's kind of the qualitative element, is that if you remove that element, would the piece still exist? There is an interesting take on sort of when you're collaborating, contributing to works, which often happens with like what's it called? Sessional artists who are playing, let's say, on albums. I know that there was, I think it was with Sarah McLachlan, there was a case where somebody sued saying they contributed a certain amount to the song, but there really wasn't that expectation or that contract or that really qualitative amount that meant that they were at the level of joint authorship. So, I think it also comes down to contracts as well and expectations. Um, you know, uh, because if you are hired to do a piece of work and there's no recognition that you will own the copyright afterwards, then the first owner of the copyright would be the employer. It's very vague. That's the thing about the copyright is there's some things that we get definitions for, and some things like substantial, original, there are no definitions for, and so the case law kind of fills in those gaps. And so the case about the substantial taking, the one that's usually referenced is it's CNR Corporation versus Robinson, and it was about a children's show and whether there were substantial parts that were taken and copied from the original, which is interesting because, you know, both works are based on a public domain work. So it was really looking at the elements that were taken, and were they substantial parts? And if you took it out, what would that mean? Would the show be able to continue as is? And it was found that no, it would not be able to continue as is. Yeah. It does. It varies country to country. Some is 50 years after the composer passed away. Some is 70 years. So it's not like person dies, you can take it. It's a long time. Canada's at 70 years. It was recently actually made 70 years so that we would be in line with the Americans. I think it might be a bit too long, 70 years. Um, but yeah, it's 70 years from the author's passing. And if it's a joint authorship, it's from the most recent author that passed. So the example I like to give when I'm giving this lecture is the musical West Side Story came out in 1957. There's three, sometimes considered four creators of the work: Jerome Robbins, Leonard Bernstein, Arthur Lawrence, and Stephen Sondheim. Stephen Sondheim just passed away in 2021. So we will be now waiting from 2021, 70 years, and for a work that came out in 1957. It's a long time. No, I would actually say that it would be on the other side of rewarding the creator, that you want the creator to be able to earn a living from the work. So that's why it's usually the lifetime of the creator. And then the 70 years after is usually the estate or 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 any is usually estate or its descendants being able to earn something from that. But I don't know about that. Maybe probably not. Um, Does Mozart have any design? He died really young. Um, no, but there is, I mean, there is also elements of that there are certain corporate interests that want to maintain control over their copyright because it's super important, aka Disney. So that's Disney lobbied actually the Americans in 19, I think in 1977 to update the Copyright Act. If I'm correct. Would not be the creator, but be the owner. A very different terms. uh, I would have to look at that deal. Yeah, I mean, they could have exclusive license to the recording. They could own the song, but allow for an exclusive license to Phil Collins to perform the song whenever he wants. There are many, if he doesn't own it, yeah. Yeah. I would think that that could actually be the case. Uh, you know, music contracts are very, very weird. There's different types. There can be so many different arrangements that I wouldn't be able to comment unless I know exactly what's going on. But I know from like my musical theater knowledge, because there's Disney theatricals, that typically Disney owns the shows, which is not the standard. Usually in musical theater, it's the author owns the show, the creator. Yeah. And they would usually hire, they pay well, but I think, yeah, when, you know, let's say, uh, probably, but I wouldn't be surprised if it becomes more common. Um, you have, I believe Concord Music just purchased RKO's catalog, which probably with probably the eye to at least make some sort of adaptations of their films into musicals. Concord would then probably own the rights to that musical. They would hire the writer to write it. I would have to see what the contract would entail, what kind of writer. I mean, if it's going to be a Stephen Schwartz, he might be able to say, no, I want to own this work, or I want a certain percentage of ownership of the copyright. So it would really depend. I know that Wicked is Universal Theatrics. So, but I'm unclear on who owns the copyright to that. Yeah. Yeah. It gets so hairy. So that's why it's like when you give like specific examples, I'm like, oh my God, I could not tell you unless I saw the contract or I knew about it. And sometimes you're just not going to know. Yeah. Propose the theoreticals. And of course, a lot of these are deals that are happening in the States. And, I know that you mentioned you have American audiences, but as somebody who's learned law in Canada, I could probably really only comment on Canadian copyright law. Yeah. Yeah. Be my ASCAP. Well, I was in the States, so I know I was in the musical, world. The two big were BMI and ASCAP. So, well, they would have to show that they were ownership. You know, just because songs might sound similar, and I know so much of our popular music today is based on the four chords and can sound really similar. There is this idea that, like, if the music you know, is created without, there has to be an element that they were exposed to that work and knowingly and like copyrighted it. When we talk about the blurred line situation, it's because I think it was Pharrell Williams who came out and said, well, we wanted it to sound like Got to Give It Up. And so they were clearly then there was that knowledge of copying. So if two songs are very similar and they're created in vacuums, they're both legit. I think that, if I was that person and I got like a cease and desist letter being like, you stole my work, you stole my song, this sounds exactly like this, I would probably get some sort of legal representation at that point. And they will work with you in saying, like, and trying to come up with that evidence of showing you were the ownership, you had no, this is clearly created separate in a vacuum, you were not exposed to their work, this is, influenced by another area, because, you can have two people who are influenced by the same thing. If you're both influenced by, Beethoven's Seventh, and it both shows up in your work and it sounds similar, but the basis for us is in the public domain. I mean, you're not copying that. So, if you're both basing your song off of, the four chords, they're going to sound similar, but that doesn't mean you were copying somebody. Um, and that gets into AI, which makes it even hairier because AI is pulling from a vast amount of catalogs and sources, and you can potentially have two people put in slightly similar prompts, land up with similar songs, and most of the time these music platforms like Clay or Suno, they will indemnify themselves saying we are not responsible if you get similar works, but it will probably, unfortunately we haven't tested this theory, but how would you be able to sue another person who both of you used the same platform and landed up with pretty much the same song? I don't think that would hold up in court. I don't know what the court will say. And that's the thing. Yeah, if you try to sue each other, I mean, it would just be really difficult in determining if there was actually any copyright infringement in the judgment. Yeah. Mhm. Mhm. Yeah, but you also don't want to create a monopoly for this person to have a prompt. It'd be so beyond that you know, it would it would mean that it would affect other people's abilities to create with that prompt. So, and that's the thing, if you put in a prompt, you will get the same prompt, you will get different creations each time. So yeah. So, I mean, there is this argument, which hasn't been tested in common law courts, of is there copyright within prompts? Where would that be? Or is it so beyond, the skill and judgment, because it would be too over encompassing. There's a lot of questions around AI that we just have not solved yet. It's a very exciting time. But there's a lot of answers where it's like you'll go and speak, be like, hey, and we can give our best guess, but it's like, I'm not sure. I mean, there's a general consensus that AI cannot be an author in copyright. So if you are putting in a prompt and you get, in Midjourney or ChatGPT of a picture, you cannot claim copyright in that. That's no one, no one. Yeah, yeah, yeah. I mean, yeah. But if there's a level of human involvement in the creating of the piece, then I mean, that's the line, is how much human involvement is needed to make a work copyrightable, or what would be the copyrightable elements in that piece. Mhm. 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 I mean, there is a skill to prompting. 100%, there is a skill, and perhaps the recognition of that will end up making something about prompt writing copyrightable. But at this moment, it's just, I just don't know if that would be possible, or is it just a skill that is uncopyrightable? But there are elements of I mean, when we were talking about Suno, I mean, when I was showing the terms of services and what you do get when you prompt, and depending on what you pay for, and if you get the premium or the open source or the free account, is, you might not be able to even own that work regardless. So I think that's another element of just being aware of what are these platforms saying. And when you are engaging with them as a tool, I'm not anti AI creating using AI to create art. I know that there are a lot of artists out there who are extremely apprehensive, who are, extremely against it. I fully understand why, but I'm more hesitant, I'm more skeptical, but I'm not completely anti it. Do I use it for my own creation, my own art? No, but I also understand if other people want to use it. That being said, if you're using these platforms, you have to understand that these don't function like a Sibelius or, RIP. Isn't Sibelius doesn't exist anymore, right? Or no? Yeah. Or like Finale. Yeah. Yeah. So, these aren't like Sibelius or Finale. There are terms of services that, indemnify them, can put you in, essentially contract with them over certain dispute resolutions. You have to look at what do they say about copyright or content. Sometimes they don't even use the word copyright, they use the word content or output, input. And, you know, you have to really be aware of what you're signing up for and what you're using it. Because if you want to try to copyright something, currently there is a case going up in the Canadian courts called Sipek versus Sony. Sony registered a piece of work that was created fully with using AI. Sipek, which is, I never remember the full name, but it's Center for Internet Public Policy at the University of Ottawa, which I internet. They um, they are challenging the registration, saying you can't, the Canadian Copyright Board cannot recognize this registration. So if you're creating using these systems, like you might not be able to copyright it. If you can't copyright it, how are you going to be able to exploit that? If you exploit that, it can, if let's say you use it in a film, that could put that film's errors and admissions insurance up. It lands up becoming a whole kind of steamroll effect that artists need to be aware of. So, when you're creating using these systems, 100% you can use them. It should, but you have to really document how your involvement in the creation of the piece is what's copyrightable, is what makes it a piece of authorship that is original, of using your skill and judgment, that makes it copyrightable according to Canadian law. Yeah. Mhm. I had to put finale when I on my so I could read my composers that I would work with. I'd have to be able to read their sheet music on finale. They would send me the score through finale, and it was not easy to use that system. So, you know, but it's yeah, as you say, like creation can be at the press of a button. And I mean, the issue is like also where is all of this work coming from that makes it accessible to create music at the push of a button? What does that mean about creation, about artistry? What is artistry? It brings up a lot of questions about copyright, about art, where we're heading, how we got here, even. That was one thing. It's so funny that we're doing this discussion on, copyright and talking about AI because, today the Canadian government released their AI national strategy, called AI for All. And there was really not, it was more about how we can improve our country using AI, the corporate interests involving AI, but it was nothing about what has happened to the culture, the art, the copyright that has already been used to train these, large language models, and what Canadian responses should be to that, because they talk about wanting to protect Canadian culture, but in a lot of ways, I feel like our culture's already been stolen. Our art, our works. Well, I mean, there are cases, there is the Sony case. There's other Toronto Star is also suing OpenAI for alleged copyright infringement. So, there is Canadian responses as much as the States. No, there's like at least 70, 80 cases in the States involving this stuff, which is huge. And there's others all around the world. So, yeah, I mean, oh yeah, I mean, I feel like like we're talking now today, and I feel like a week from now, when you publish this, the law could be completely different. you know. The lyric, though, is interesting because if he wrote the lyric by hand, if this was, his creation, that's the copyright element. And there was a really interesting case, I think in Germany, that just came out, where somebody wrote lyrics by hand and then the song they used AI. And then somebody copied that song using the AI system. And the idea was like, well, where is the copyright? Is there a copyright? And the element was that the lyrics that were written by hand and put essentially into the system, that was copyrightable. And so therefore it was an infringement. So that's where we're seeing where things are starting to emerge. But it's slow, the legal system does not move fast. Yeah. 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 You can just Google my name, but if they want to reach out to Wula, they can if they have questions about the law. And yeah, they can also reach out to me through there. Yeah. Mhm. Keep on, yeah, litigating would be the right word. Copywriting, I don't know. I know that sounds like really. Keep on copywriting. Keep on writing. Writing is rewriting, guys.